All right, this is People versus Robert Mitchell. It's case number 2012461 FH. Mr. Mitchell is here for his final conference. His case was set for trial in April. However, the attorneys asked the court to adjourn that trial because the defense attorney had a previously scheduled vacation. The court did agree to that. Case is now set for trial July 14th, 15th, and 16th. So we're here today for the final conference in this case. And Mr. Stay, did you have a final offer to make in this case?
The offer was for the defendant to plead to count 1 with habitual offender, 3rd offense notice. People will dismiss count 2, dismiss habitual offender, 4th offense notice, 0 to 25, cap at 18 months.
And there was a 3rd count as well. Are you dismissing that?
Yes.
All right, so plead to count 1, dismiss 2 and 3, reduce the habitual offender 4th to a 3rd with an 18-month cap.
Correct.
All right, and Mr. Prysock, is that the offer that was conveyed to you?
It is good.
And have you had the opportunity to discuss that with Mr. Mitchell?
I have good.
And does Mr. Mitchell wish to take advantage of that agreement?
Mr. Mitchell wishes the trial to go forward on July 14, 15, 16. Ron?
Is that correct, Mr. Mitchell, that you are rejecting that offer and wish to go to trial?
Yes, sir.
Your Honor, it was 1 and 3. I'm sorry. I don't know why I wrote it down correctly.
No, the 1 and 3 was your offer from September.
It was the original offer, and I have communicated that correctly to Mr. Prysock.
All right, so the offer is plead to count 1 and count 3, 2 4-year felonies, being a habitual offender 3rd, which would raise the maximum penalty to 8 years with an 18-month cap. Is that correct?
Correct, Your Honor. Thank
All
you.
right. And Mr. Mitchell, that is still your agreement or still your understanding of the plea agreement in this case?
Yes, sir.
All right. And you are rejecting that offer, is that correct?
Yes, I am.
All right. And you have had an opportunity to discuss that with Mr. Prysock, is that correct?
Yes, sir.
All right. And do you understand that probably the main benefit of this plea agreement is that they're dismissing the habitual offender 4th, which could increase the maximum penalty in this case from 4 years to 15 years. Do you understand that?
Yes, sir.
And also the advisory guidelines would be different for a habitual offender 4 versus habitual offender 3rd. You understand that?
Yes, sir.
All right. And you understand that the other benefit of this agreement is that you would have an agreement not to exceed the advisory guidelines in an 18-month cap, whereas if you go to a trial and you are convicted, you would face the possibility of receiving a greater sentence than the 18 months. Do you understand that?
Yes, sir.
All right. And bearing all that in mind, you still wish to proceed to sentencing, is that correct? Or proceed to trial, is that correct?
Yes.
All right. So as I indicated at the time of your last pretrial conference, that today was going to be the last day to take advantage of any sort of plea agreement. So your choices now going forward are to either go to trial, which you've indicated that you want to do, or to enter a plea of guilty as charged without any sentencing agreement. It does not mean that you're going to that you would receive the maximum sentence, but just that the court would not be bound by any sentence agreement reached between the attorneys. Do you understand that?
Yes.
Okay, you've got your trial date. That's all for today.
Judge, we're not seeing the YouTube live stream online. just thought I'd bring that to the court's attention. We're not seeing the YouTube stream.
That happens sometimes, even though it says that we're live streaming. Sometimes it'll post later on during the day. We can't figure out why that happens.
I just thought I'd bring it to the court's attention.
That's Mr. Friends.
Yes, Your Honor.
All right, you're just a little bit early, Mr. Friends, but I guess since you're there, well, hang on. We're gonna put you back in the waiting room, Mr. Friends. I see my 9:30 is ready to go. All right, this is case number 2012465FH, People versus Gregory Liefers. Mr. Liefers is here for a final conference. He's appearing by Zoom with his attorney, Ms. Frisbee, and Mr. Stay. Do you have a final offer that you're making in this case?
The offer is for the defendant to enter a guilty plea to count 1 and count 2 with the habitual offender 3rd offense notice. The people would dismiss the habitual offender 4th offense notice. The people calculate the guidelines at 2 to 25 months on the minimum. People would recommend no prison.
And Ms. Frisbee, was that the offer that was conveyed to you?
Yes, it was, Your Honor.
And have you had an opportunity to discuss that with Mr. Liefers?
Yes, I have.
Is that correct, Mr. Liefers?
That is.
All right. And Ms. Frisbee, does your client wish to take advantage of that plea agreement?
No, he does not.
Is that correct, Mr. Liefers?
That is correct.
All right. So this agreement has one major component to it, well, two actually, that they're dismissing the habitual offender 4th, which could increase the maximum penalty for count 1 from 2 years to 15 years, but they're reducing that to habitual offender 3rd, which would make the maximum penalty go from 2 years to 4 years. Do you understand that?
I do.
And the other benefit is that this is a no prison recommendation, whereas if you go to trial and convicted, your sentencing guidelines, although they are advisory, could suggest a prison sentence for you. Do you understand that?
I do.
Under this agreement, that if the guidelines are 2 to 25, the least that you could get is 2 months in the county jail, but you could get no more than 1 year in the county jail. Do you understand how that works?
I do.
All right. All right, and after consultation with your attorney, you're rejecting that offer. Is that correct?
That is correct.
All right. So going forward, Mr. Liefers, your options are to continue to trial, and you are set for trial, or you can enter a guilty plea unconditionally to the charges. After today, the court would not be bound by any sort of sentencing agreement that would be reached between you and your attorney. Do you understand that?
I do.
I didn't hear that, sir.
I do.
Okay. It doesn't mean that you're going to necessarily get the maximum sentence, just that the court would not be bound by any sentencing agreement. And you understand that, right?
I do.
All right, that's all for today. And we've got your trial set for April 28th, 29th, and 30th.
Right, thank you, Your Honor. Here.
Okay.
Just giving you text books and make an appointment.
We just have Mr. Friends waiting.
Say that again?
We just have Mr. Friends waiting.
Yep, bring him. All right, this is case number 2012543 FH, People versus Paul Friends. This case is set for sentencing today. And Mr. Friends, do you understand that you have the right to be physically present in court for sentencing?
Yes, Your Honor.
And do you waive or give up that right and agree to handle today's proceedings remotely?
Yes, Your Honor.
Prosecution and defense, was the pre-sentence investigation report timely made available to you?
It was, Your Honor.
Yes, Your Honor. Sorry.
It was, Your Honor.
All right. And Ms. Frisbee, do you have any additions, corrections, or challenges to that report?
Wait. With regard to the sentencing guidelines, I do have let me see. Okay, well, first of all, on there's no page number. Under his criminal history, I'm looking at 2 or 3.
All right, hang on just a sec. Okay, go ahead.
Number 2 or 3, my client was never convicted of that. I don't know if he had the Spouse Abuse Act, but it never was entered as a conviction.
Right, that's the way I took it, that it was a 10-month deferred. Mr. Zirup, is it your understanding that Mr. Friends successfully completed that deferral?
I'm looking at that right now, Your Honor. Yes.
All right, yeah, so that is something that's on there, but I did not score it on the advisory guidelines, and it doesn't appear that Mr. Zirup did either.
Okay, wanted to make sure. And then on the last page, the offense variable 19 has to do with interfering with public administration of justice. And I think that the fact that it was a fleeing and eluding takes that into account, and it should not. My argument is that it shouldn't be scored because the elements of the offense take that into account.
Mr. Stay, any response?
It should be scored. There is no exemption because the elements take into account.
Right, I agree that offense variable is properly scored in this case. So I am going to score offense variable 19 at 10 points. There's a case right on point. I don't have the name of it off the top of my head, but there's a case right on point.
All right, thank you, Your Honor.
Anything else, Ms. Frisbee?
No other deletions or corrections.
All right. Is there anything that you want the court to consider before the court imposes sentence?
Well, my client only has the 1 prior misdemeanor. I'd like you to take that into account. I mean, I understand it's a 30-day cap. If you would consider sentencing to less, he has strong ties to the community. He lives in Fremont. Part of this is that his the motorcycle that he drives is very, very distinctive, and I think that's how this pretty much came about. I think the 10-month deferral is the best way to go, but I don't think that jail time at this point is appropriate. I don't think it's necessary for my client. I think he's learned his lesson in this situation, and ending up with a felony initially, before it gets reduced, is a plus the restrictions on his license. I mean, I think that's going to be penalty enough. Thank you, Your Honor.
All right, and Mr. Friends, have you had the opportunity to read the report and discuss it with Ms. Frisbee?
Yes, Your Honor.
Do you have any additions, corrections, or challenges to that report?
No, Your Honor.
Is there anything that you want the court to consider before the court imposes sentence?
No, Your Honor. I think Ms. Frisbee and I have gone for what I was looking for anyway.
All right. And Mr. Stay, any additions, corrections, or challenges?
Your Honor, I would just ask that the plea agreement indicates that 10-month deferral delay of sentence is to the charge of reckless driving.
All right, we'll add that information to it.
Otherwise, I do not have any additions or subtractions, and I have nothing further to tell the court.
All right, the court recognizes that the advisory guidelines in this case would suggest a sentence between 0 and 9 months. The court can exercise my discretion, sentence consistent with the advisory guidelines and consistent with the plea agreement in this case. The court is going to impose 7 days in the Nuevo County Jail. There is no credit to be given because he was never jailed on it. There's a $68 state cost, $130 Crime Victims' Rights Fund fee. The court is going to place him on supervised delay for 10 months. There's a $30 per month standard probation fee. There's a $100 fine, and there's a $100 cost. And if Mr. Friends successfully completes this 10-month delay, which I would expect that he would, the court would then allow him to withdraw his plea and plead to misdemeanor reckless driving. And for a 10-month deferral date, we'll set this case for sentencing on November 2nd at 8:30 in the morning. And Mr. Friends, you need to report to jail today by 3:30 to begin serving your 7-day sentence.
May I speak, Your Honor? I apologize.
Okay.
So for the 7 days jail, I was under the impression that it would just be held over my head. But I guess at this point, now that there's nothing held over my head on this one, the only reason that there's even a case is the fact that I turned myself in. There was no proof of me doing any of it. And I turned myself in like a grown man, which I'm sure not many people would even do, especially in terms like this. And I'm not saying that I don't deserve jail time, but I do believe that at least, I guess, in a situation where most people wouldn't man up, I know that I've done wrong, and I know that I've already lost my license. That's been lost on December 6th of this 2020. But I have VA appointments that I have to go to, and I just had surgery last week in which I have to have a follow-up with Dr. Hood as of tomorrow. Is there any other way that I could weekends or any other situation possible, or any leniency to being able to get the 7 days up with knowing that I turned myself in without problem?
Well, it's not exactly that you just turn yourself in and that they never would have caught you, but for that, because they did have the silent observer tip that recognized either you or your motorcycle as being the one that was involved in the fleeing and looting, I do give you credit for the fact that they did contact you. You came in and you did confess, for lack of a better word, or admit to what you had done. The cap was 30 days. I took that into consideration and imposed the 7 days. So I already cut it down from what the prosecutor was recommending because you did do that. But this isn't your first brush with the law. You do have some other contacts, which is not good. So that's why I imposed some jail time. Now, with the current coronavirus and COVID situation, we're not doing weekends. But if you have scheduled VA visits or scheduled follow-up visits with your physician that you can tell me now, I can see if I can work around those for you. So in the next 7 days, do you have any VA appointments scheduled?
Yes, Your Honor. I have tomorrow. I have an appointment with Dr. Hood because I just had surgery on my left elbow, and then I do have an appointment with Dr. Alice out of the VA.
All right, you cut up there. I didn't catch the last part of what you said. I understand that you have a doctor with your orthopedic surgeon follow-up tomorrow.
Yes, Your Honor. And then the other one was the therapy with Dr. Malice out of the Wyoming VA clinic.
When does that start?
I believe it's at 10:40. I'd have to look at the paper, but I believe it's on Thursday. I know it was this coming week or this week.
And what's your frequency of that therapy?
I have them as of right now with Dr. Malice. It's once a month, and then I have a different set of counseling that I go to that is through Harvest Church. But as a reason I started the Harvest Church therapy or counseling was because driving to Wyoming more than once a month it's a good drive. So I choose to do a different therapy as well throughout the month.
All right, so why don't you report to jail Friday, January 8th at 7 o'clock at night.
Yes, Your Honor.
And then that'll get you past your next two appointments. You probably get a day at good time, so you'd probably be out the 13th or the 14th.
Yes,
next
Your Honor.
week. All right, we'll do it that way then. So just so we're clear, the report time, January 8th, 7 p.m. All right?
Yes, Your Honor.
Now, there was some financial assessments. Can you pay those today, sir?
I cannot pay those today.
All right, how much time do you need?
I don't even remember the amounts in which were in.
It looks like it's just under $400.
A month? Would that be?
No, just flat, just $400. And then it's $30 a month after that for your probation oversight fee.
Okay. Is there any way that I could pay that on the first of next month?
All right, the court will give you 30 days to pay your financial assessments.
If I get the money, I'll be able to pay that earlier, though, correct, Your Honor?
Yes, you can pay it at any time. All right, so you're going to report to jail this Friday, 7 o'clock. You've got your 10-month deferral date for November 2nd at 8:30. That's all for today.
Yes, Your Honor.
Now, are there license restrictions?
They're imposed by the Secretary of State, not me.
Okay, they got reported early, so he's already done his 30 hard on that.
Okay. All right, so it looks like next up is Erica Jackson at 10 o'clock. So we can stop the live stream.